case it is being violated. The Supreme Court under Article 32 Clause 2 has been given the duty to safeguard our fundamental rights. That is the reason why it is the Supreme Court which is considered to be the protector of fundamental rights. High Court, though it also enjoys writ jurisdiction, it is still not considered to be the protector of fundamental rights, because the duty that has been imposed on it on the Supreme Court by Article 32, that duty has not been imposed upon the High Courts. We had also seen why Article 32 is called as the backbone of the Constitution, because it ensures the integrity of our Constitution. Without Article 32 of the Constitution, the Constitution will not have the kind of integrity that it enjoys. The basic principles that are there, the basic pillars that that our Constitution has, it is not possible. It is not something that will be there if Article 32 is not present, and that is the reason why it is called as the backbone of our Constitution. The B.R. Ambedkar also considered it to be fundamental of all fundamental rights, the heart and soul of our Constitution. Similarly, later on we came to a discussion on writs. We had discussed the 5 writs. Writ of habeas corpus, which means to have the body, and it is a writ which protects every citizen of India against any kind of illegal detention, or in any way if their personal liberty is being hampered. The Supreme Court, they can approach the Supreme Court, and the Supreme Court can issue a writ of habeas corpus providing them with the same rights. We had also discussed something called as the principle of locus standi, and we had seen that in habeas corpus the principle of locus standi is not applicable. Then we had come to the second writ, the writ of mandamus, which means we command. It is in the nature of command issued by the court to the public authority or an individual in public office to perform a duty which it has failed to perform. It is for our legal rights. Mandamus, the writ of mandamus is for our enforcement of our fundamental rights as well as legal rights when it comes to the courts. The High Court can issue it for even legal rights. However, it cannot be issued against the President and the Governor. Why? I had explained that idea yesterday. Then we came to the third writ, the writ of prohibition, which is issued by a higher court against a lower judicial or a quasi-judicial body to prohibit it from exceeding any jurisdiction that it has. Again, the locus standi principle is applicable both in mandamus as well as in writ of prohibition. Writ of certiorari, which is a similar writ, it is similar to the writ of prohibition in almost all respects, except for the fact that writ of prohibition is only preventive in nature, whereas writ of certiorari is also curative in nature, wherein it does not just prohibit the lower judicial body, but it also quashes any kind of judgment that has been given by the lower judicial or a quasi-judicial body in excess of its jurisdiction. Then we came to the last writ, the fifth writ. The fifth writ was the writ of quo warranto, which means by what authority, and we specifically we had specifically seen that this writ is issued again like the writ of mandamus. It is also issued against a public authority or an individual who enjoys public offices to ascertain the legality of his appointment to that public office. So writ of quo warranto can be issued or is issued to ensure that there is no illegal assumption of any public office. There is no illegal assumption of any public office. And we had also seen that the principle of locus standi is not applicable. So it's not applicable in two of the writs, the writ of habeas corpus and the writ of quo warranto, but it is applicable in the other writs, mandamus, prohibition and certiorari. It is applicable, the writ of the principle of locus standi. Now, before we get into our discussion of directive principles, there is one more thing that we need to discuss here, that is comparison between the writ jurisdiction that is given to the Supreme Court under Article 32 and given to the High Court under Article 226. So if you see, if you go by the discussion yesterday, the Supreme Court has been given writ jurisdiction under Article 32 of the Constitution and the High Court has been given writ jurisdiction under Article 226 of the Constitution. If you remember, we had said that there is a difference between, yesterday in course of our discussion itself, I just mentioned that there is a difference between the writ jurisdiction of the Supreme Court and the writ jurisdiction of the High Court. So what is this difference? Article 32 of the Constitution, which empowers the Supreme Court to issue writs, it empowers the Supreme Court to issue writs only in case of enforcement of fundamental rights. Only in case of enforcement of fundamental rights. Whereas Article 226 empowers the High Court to issue writs not only in the case of enforcement of fundamental rights, but the High Court can also issue writs for enforcement of other legal rights. Other legal rights. Under Article 32 of the Constitution, the Supreme Court, for redressing the encroachment of fundamental rights, it is mandatory for the Supreme Court to issue writs. Whereas, if you look at the High Courts, it is not a duty. For High Courts, it is not a duty. Therefore, there is discretion that the High Court has. There is discretion that the High Court has, but this discretion is not present when it comes to the Supreme Court. When you look at the territorial jurisdiction, the territorial writ jurisdiction of the Supreme Court is to any part of the territory of India. So any body that is there, or for that matter, any individual, any citizen of India, that can be done. But this is not the case for High Courts, because for High Courts they can issue writs, and this territorial jurisdiction of the High Court is the concerned jurisdiction, which means the territory of that High Court, the territorial extent of that High Court that is there. So the writ jurisdiction of the Supreme Court, where it extends to all the territory of India, writ jurisdiction of the High Court is only with the concerned territory. It's not the concerned state, it is the concerned territory. I have not written the state. Why? Because the jurisdiction of the High Court is not just in the state, it is also to the concerned UTs. It is also to the concerned UTs. So the union territories that are there, they are also under the jurisdiction of a concerned High Court. No, they are also of a jurisdiction of the concerned High Court. So you will find that when we talk about Lakshadweep, when we talk about suppose Daman and Diu, when we talk about other high courts that are there, other UTs that are there, some of those UTs they are under the jurisdiction of a certain High Court. They are all under the jurisdiction of a certain High Court. So that is also the case here. Clear? So the concerned territory, not the complete territory of India or not the complete territory of only the state, it is the concerned territory. Clear? So if you compare the writ jurisdiction of the Supreme Court and if you compare the writ jurisdiction of the High Court, what is the conclusion that you draw here? Yes, what is the conclusion you draw? What is the conclusion that you draw if you look at these provisions? Guarantor or no, the Supreme Court guarantees, or the Supreme Court is a protector of fundamental right. Do you if you look at these provisions while comparing the writ jurisdiction of the court, this is what you derive. Does the Supreme Court or can the Supreme Court issue only writs to protect our fundamental rights? Does the Supreme Court issue only writs to protect our fundamental rights? No. Yesterday what did I say? I said directions and orders or writs. So can the Supreme Court only protect our fundamental rights by issuing writs? No. So how can you, just by comparing writ jurisdiction, how can you actually derive this, that Supreme Court is the protector of fundamental rights? Because the Supreme Court can do that even without its writ jurisdiction. Even if it does not issue writ, it still is a protector of fundamental rights. Is that what you conclude while comparing the writ jurisdiction of both the courts? I am just talking about the writ jurisdiction. Is that what you conclude? No, that is what is written. I am saying what is the conclusion? The conclusion is that the writ jurisdiction of the High Court is more than the writ jurisdiction of the Supreme Court. The writ jurisdiction of the High Court that is there, leave aside the territorial extent. Leave aside the territorial extent. Yes, when it comes to the territorial extent, the Supreme Court has the territory of the whole of the country. So it can issue writ for any part of the country. Except for that, what is the conclusion here? The conclusion here is that if you look at compare the writ jurisdiction of the Supreme Court to that of the writ jurisdiction of the High Court, the writ jurisdiction of the High Court is more, because not only can it issue writs for enforcing other legal rights, it can issue writs on its own discretion. It is not mandatory for the court to issue writs. High Court, it's not mandatory, it is his choice. It is the court's choice, and it can do that for enforcement of our other legal rights as well. But that is not the case when it comes to the Supreme Court. So the writ jurisdiction of the High Court is much more than the writ jurisdiction of the Supreme Court. The only difference being, the only point that actually makes Supreme Court's writ jurisdiction more, what you can say, more substantive is the fact that it is valid through all through the territory of India. Otherwise, the writ jurisdiction of the High Court is more than the writ jurisdiction of the Supreme Court. It is the scope of its writ. The scope of its writ jurisdiction is much more. Clear? This is what we conclude. Because if we talk about fundamental rights, the protection of fundamental rights, Supreme Court can issue directions as well as other orders. Not necessarily the Supreme Court has to issue writs, but if it is mandatory for the Supreme Court to issue writs, it will have to issue writs. It is not a discretionary power. It's not a discretionary power. But when it comes to the High Court, no such duty has been imposed. No such duty has been imposed. So it is its discretion whether it wants, whether it does it or not. It's not a constitutional duty. And similarly, the High Court can issue it not just for protection of our fundamental rights, but also for protection of other legal rights. So don't you conclude this? So the conclusion is not that the Supreme Court is a protector of fundamental rights, rather the conclusion is that if you compare the writ jurisdiction of the High Court with that of the Supreme Court, the writ jurisdiction of the High Court seems to be more than the writ jurisdiction of the Supreme Court. Clear? Clear? Absolutely clear this idea? Now with this we complete our discussion on writs. I am no more going to talk about Article 226 of the Constitution. I have already discussed it. Because the same writs are mentioned, I have already discussed what are those writs, and I have also compared Article 32 and Article 226 of the Constitution. Clear? With this, we complete our discussion on fundamental rights. This is where we complete our discussion on fundamental rights. We have now any question that comes on fundamental rights, you will be able to answer now. Any questions? Now we have given a lot of time on fundamental rights. Why? Because see, over a period of time, that means if you look at the current aspect, you will find that in current aspect there have been lot of issues in which the Supreme Court has come up with this kind of judgment that a particular right that is not external or explicitly mentioned in the Constitution has been mentioned as a part of fundamental rights. Like going back to the year 2017, the Supreme Court declared 2016-17, the Supreme Court declared that right to privacy is a fundamental right under Article 21 of the Constitution. Similarly, while the Supreme Court was taking up its when the Supreme Court was taking up judicial review of Section 377, which deals with unnatural sex, and in that case the Supreme Court declared that choosing a partner is a part of right to life under Article 21 of the Constitution. Similarly, the Supreme Court, while it was taking up in one of a particular judgment, it declared triple talaq to be unconstitutional. Why? Again, Article 21 of the Constitution, it says it is against the idea of a dignified life. So again, the Supreme Court declared triple talaq as an unconstitutional idea. It was declared as an unconstitutional idea. Similarly, if you look at other provisions that are there, Supreme Court has from time to time taken up this interpretation, and in this last few years, this constitutional validity of lot of things, whether it is some of our practices, religious or cultural, that practices that are there, they have been under judicial review. Certain laws that have been made by the legislature, like the Aadhaar Act, it was under judicial review. Similarly, triple talaq is also under judicial review. Similarly, going back 3 years, there was a PIL filed. Again with respect to certain practices that are there. Cultural practices. That has been present, all these things, and that is the reason why fundamental rights, though generally there is a tendency of UPSC to not ask this when it comes to mains examination. You will not find in the last 2-3 years, you will not find a direct question on fundamental rights, but we cannot say that there are no indirect questions on it. There are some questions that are asked, they are indirectly asked, and in that case you have to mention, unless you mention those inferred rights as a part of fundamental rights or the Supreme Court's decisions on fundamental rights, those answers are not very effective. Clear? And that is the reason why I have done this. In this last week's test, you must if you have given this Sunday's test, I have made it specifically based on prelims examination. There were only multiple choice questions. which I will continue for the next test also. Why? Because again, fundamental rights are certain things, you know, the manner that it can be asked, it is very technical. The manner that it can be asked, sometimes you will find that if you read the question and if you don't pay attention on what the question is, you are likely to make a lot of mistakes. So I have ensured, is as a part of my discussion in fundamental rights, I have ensured that I have dealt with each and every aspect of our discussion in fundamental, which we can actually take up in the class. Clear? So this is where we end our discussion on fundamental rights, and we start with the next topic, that is part 4 of the Constitution, which deals with directive principles. Directive principles. Part 4 of the Constitution, directive principles. What are directive principles? Yes, what are directive principles? How can you define this idea of directive principles? These are, they are guidelines for good governance. Okay. They are like guidelines for good governance. Okay. What do you mean by this? Instrument of? It is instrument of instructions. Why do you need to use the term instrument of instruction? Just say it is instructions. These are like guidelines, these are instructions. These are directives, or these are instructions. Instructions for what? Instructions for policies. Okay. These are instructions for formulating certain laws or policies. The question is why? Why does the Constitution need to give directions? To establish a welfare state. Yes, this is very important. When we say that these are instructions, or for that matter, when we talk about guidelines of good governance. So when we say good governance, the idea of good governance, what you also need to understand is the idea of good governance is administrative. That means good governance is the manner or the way you take up governance. So when we say good governance, good governance, when we use the term good governance, we basically are referring to the manner in which governance is taking. We are not talking about the qualitative nature of governance. We are talking about the manner in which it is taken up, which means we are with the idea of good governance, we tend to do what? We tend to include this, that governance is taken up in a manner like with transparency, with participation. These are the ideas that are core to good governance. So rather than saying that these are guidelines to achieve good governance, more appropriately we can say these are guidelines or instructions or directives given to the state. Remember, just don't write it as directives. Directives to whom? These are directives given to the state with an objective of what? With an objective of establishing a welfare state. With an objective of establishing a welfare state. Now, for those who technically do not understand this concept of welfare state, what you need to understand is that there are two kinds of states that are present. First is called as a laissez-faire state. A laissez-faire state. And the second is called as a welfare state. What is a laissez-faire state? A laissez-faire state is a state wherein the state has some limited activities. The state, the government that is there, it performs some limited functions. What are those functions? More in line of this, more in nature of maintaining law and order, ensuring that the state maintains law and order, as well as the state is there to collect taxation, etc., etc. That's it. Now, the state does not, the state is a state which is a limited state. A laissez-faire state is a limited state. Whereas, when we say a welfare state, what is a welfare state? A welfare state is is that kind of a state which ensures, which deals with, which has, which takes into account each and every aspect of a citizen's life, thereby not constraining itself or restricting itself to only performance of some limited functions like maintenance of law and order. It ensures that states go beyond these activities and take up certain role, adopt this role of welfare. That means ensuring that the citizens, they enjoy a certain condition, a certain environment in which they live, wherein it provides services such as health, education, even economic restructuring or redistribution of wealth. All these activities are taken up by a welfare state, which is not the concern of a laissez-faire state. The idea of laissez-faire, when we talk about when we talk about a liberal state, when we talk about a libertarian state, wherein the state is restricted, the libertarian philosophy was given by an individual called as Robert Nozick. And Robert Nozick was of the opinion that state is responsible for, the state should be responsible for taking up only certain things. The state should not have this responsibility of coming up with paternalistic laws. What is paternalistic laws? Paternalistic laws like if you come up with laws like seatbelt laws or helmet laws, which has an objective of what? Saving ourselves from ourselves. This is what it does. The libertarian philosophy says that this is immoral. Why? Because the state is imposing on us. The state is curbing the liberty of an individual. Similarly, the state should not impose morality on the society. The state shall not impose that. So polygamy laws, suicide laws, such laws that are there, these laws are not moral. So that is where the laissez-faire state, that is the kind of a laissez-faire state. You can see the nature. No paternalistic laws. No paternalistic laws means what? No laws which which takes up in this nature, like ensuring that there are seatbelt laws, traffic violations, all these laws that are there, or for that matter moral legislations, some moral legislations that are there. You can see there are some moral legislations that are imposed on us. Gujarat is a dry state. Similarly, Bihar is also a dry state. It is what? It is morality. State is imposing morality. Polygamy is prohibited. Polygamy is prohibited. Such things that are there. What is the state trying to do? That kind of state which is responsible for regulating each and every aspect of our life. Each and every aspect of our life, ensuring basic services are provided to all. Basic services are provided to all. No one is deprived of these services, or for that matter also ensuring that there is some kind of redistribution of wealth. The economic status of all citizens are similar, if not equal, at least similar. That is what the state is guaranteeing. So when we talk about welfare state, this is what is a welfare state. And when we talk about directive principles ensure the existence of a welfare state. Why not fundamental rights? Why not fundamental rights? Why am I saying that directive principles ensure existence of welfare state? Why did not I take this up when we were discussing fundamental rights? Absolutely correct. Absolutely correct. These are why welfare state is established by directive principles? Because when we talk about welfare state, that is providing services, if you remember, when we were talking about fundamental rights, the nature of fundamental rights, I said these are negative obligations of the state. It has to be done. There is no way out. It has to be done. That is not the case when it comes to directive principles. And the nature is such, it is more of social and economic nature. Fundamental rights are more of political nature, not social and economic. Why? I am coming to that. It is more like political in nature. Fundamental rights. But when it comes to directive principles, this is more of a social and economic nature. It has that social and economic nature. So when we talk about, suppose if you remember, go back to our discussion on preamble, and we said that we were discussing a value called as democracy. And when we discussed democracy, I said that democracy is not just political, it is also social and economic. Because when we use the term democracy in our preamble, it does not just denote political democracy, it also denotes social and economic democracy. So when we say fundamental rights, what is fundamental rights? Fundamental rights ensures the existence of political democracy, whereas directive principles ensures the existence of economic and social democracy. Economic and social democracy. Just think of it. Just think of it in this manner. What is political democracy? Political democracy simply means that who is responsible for taking decisions. We describe democracy as how? We say by the people, for the people, of the people. So if people themselves are involved in decision making, however, through direct, it may be through direct or it may be through the representative democracy, that we elect representatives and they take decisions for us. So what kind of decisions we are talking about? We are talking about what kind of political structure will exist and how they are going to take decisions. When we talk about social democracy, what is social democracy? Ensuring that everyone has equal say in social decision making. Everyone has equal say in social decision making. And how, or is it possible? Is it currently existence? No. Why? Because there are various norms in which the society is divided, and because of this what we get is a society which is hierarchically organized, and in that case some individuals are more empowered than others. So when we talk about patriarchal norms do what? It ensures men in the society are more responsible, or more, what you can say, they are more empowered to take social decisions. They decide on behalf of everyone. Not everyone is deciding on behalf of everyone, but men are deciding on behalf of everyone. Existence of patriarchy, existence of economic disparity that exists. What does that do? It makes a certain group economically empowered, whereas the other are not. And because only a certain group is economically empowered, they are very likely to dominate either social decision making or, for that matter, economic decision making. And what is directive principles? Directive principles are of, the objective of directive principles is to ensure that this disparity does not exist, or somehow to do what? Somehow to convert this hierarchical relationship, wherein there is one who is more empowered than others, and this injustice that is present, this injustice or this inequality or injustice that is present, directive principles have the objective of what? The directive principles have the objective of redressing this. And that is the reason why we say directive principles is the principle which establishes a welfare state, because the nature of directives it is that it gives, it ensures that this redressal or this lack of rights that is given to everyone, not legally it's fine, everyone enjoys fundamental rights, but when it comes to more substantively, you will find some of us enjoy more than others. Some of us enjoy these rights more than others. Why? Because of some social some social factors or some economic factors that is there. Social factors, some of us are more empowered than others in the society because of the caste, the religion, the sex that we belong to, the gender that we belong to. On the other hand, some of us will enjoy these rights more than others. Why? Because you are economically more empowered than others. Some of them are being deprived of these rights. Why? Because they are economically not that empowered. And directive principles do what? they give guidelines or instructions to the state that how come or what are the steps that the state can do or take up to ensure that this disparity that is present, because of which some enjoy more rights than others or some enjoy more substantive right than others, this can be done away with. This disparity can be done away with. And that is the reason why it is called as a welfare state. It establishes a welfare state. Example se samjho. See, I've used this example before also, maybe in your class as well. Going back around 2-3 years, in the winters itself in Delhi, what happened was that the railways, there is a railway station in Delhi, Shakurpur railway station. What happened there was, in the Shakurpur railway station, there were some land that was present which was encroached upon by people who they had come out with slums there. They were living in temporary temporary shelters there, and the railways did what? On one day the railways did what? The railways they claimed that they had given notice to them to vacate the premise because it belongs to the state, and they were illegally, any encroachment is obviously illegal, and hence they were directed to leave the place. But the railways claimed they did not, and hence the railways did what? They destroyed their shelters, etc., and they were specifically made to vacate rather than voluntarily doing that. Because of this, what happened was 2 of the individuals died because they were living in temporary shelters, and the kind of harsh winters that Delhi faces. Because of this, they did not have those rights, right to shelter. They did not have that. They were living in temporary shelters which was destroyed by the state, and the consequence of it was that 2 of the individuals died in the next 2 days. Now we all have right to life. We all have right to life, but we enjoy these rights. Why? Because we are economically more empowered than them. Being citizens, they are also enjoying these rights. If we go by legal sense, so they are also enjoying these rights. They also have the right to life. But do they substantively enjoy these rights? No. You can see 2 of the individuals lost their life because of the harsh winters that is there. Why? Because there are some social and economic reasons why they do not enjoy similar rights to that of us. And what are directive principles? Directive principles are those directives which ensure that the state takes up certain actions. The state takes up certain actions wherein not only they are extending some legal rights, or not only they are taking up some legal measures to protect our certain rights, but or not to discriminate among us on the basis of the manner in which they give rights, but they take up certain discrimination wherein those who are socially and economically less empowered, the state takes up certain activities to ensure that the consequence of those activities are that they become more empowered, or at least they get the same status of empowerment that we enjoy. That is what is directive principles, and that is the reason why we say it helps us in achieving the goal, that is the welfare goals of the state. Clear? So these are what are directive principles. Before we get into the nature of directive principles, just an introduction of directive principles. Directive principles epitomize the ideals of the people. The ideals of the people. They have evolved. Along with the constitutional form of government, constitutional, form of government. They seek to establish a welfare state as opposed to a regulatory, or a laissez-faire state. Directive principles are in the nature of general directions given to the state. They contain the objectives which the state must have in mind while formulating policies and enacting laws. They seek to provide methods of empowerment of the people, and they constitute a comprehensive social and administrative program for a modern democratic state. Clear? Modern democratic state, we say every modern democratic state has welfare goals. It has welfare goals, whether whatever political philosophy it might follow. Some of us may have a philosophy of socialism, others may not, but they will still follow the philosophy of welfareism. No modern democratic state can ignore welfare principles. Clear? Next, give a subheading, write difference between fundamental rights and directive principles. Difference between fundamental rights and directive principles. Fundamental rights are enforceable. Justiciable rights, whereas directive principles are non-justiciable. Obviously, we have seen this idea when we were discussing the preamble itself. We said that when we were talking about the nature of preamble, we use the same terminology, that they are non-justiciable, which means preamble cannot be the basis of the court providing or deciding a judgment. Similarly, when it comes to directive principles, the rights that have been given to us or the duties that have been imposed, the directives that have been given to the state under Part 4, under directive principles, they are not enforceable, which means that cannot be the basis of a particular individual approaching the court to get or to force the state to do something. That cannot be the case, unlike that of fundamental rights, because we have already seen Article 13, Article 32, both of these that are there. Article 32, yesterday itself we were discussing, and we discussed that it makes fundamental rights enforceable.
Can we write directive principles such as DPSP in short form?
Yes, definitely, you can write that, DPSP. Second point, fundamental rights seek to establish political democracy whereas directive principles or DPSPs seek to establish economic and social democracy. Economic and social democracy. Who can explain this? We have already discussed certain provisions like didn't we talk about Article 15 Clause 2, wherein we talked about state and individuals not discriminating for access to public places, no discrimination. We did talk about Article 17 of the Constitution also, wherein we said that no untouchability is prohibited. So isn't that social in nature? Even Article 23 of the Constitution or Article 24 of the Constitution, isn't that social in nature? It is. So why are we saying fundamental rights have an objective of establishing political democracy, whereas directive principles have the objective of establishing social and economic democracy? Why? So what does that makes it social and political, social and economic in nature? Because it is not justiciable. Because it is not justiciable, that is the reason why it is, the objective of it is to establish social and economic democracy. What are these for all general people? Directive principles, no. Directive principles, Article 44 of the Constitution says universal civil code. Uniform civil code. Now, do you think in terms of uniform civil code, if we say that it is not in existence, it is because currently uniform civil code is not there in one religion.
Sir, is it 44 or 144?
It is 44. Article 44. Similarly, if you look at Article 47 of the Constitution, Article 43 of the Constitution, it talks about weaker section of the society. So how can you say it is for everyone? You fall in the weaker section of the society. No, you are not. You are empowered section of the society. So it's not for that. Saying that fundamental right is applicable for all and directive principles are not, or for that matter, when we talk about Article 15 Clause 2 and Article 17, saying that it is applicable for, Article 17 is applicable only for a certain section and not for all. That is also wrong. That is also wrong.
Majority of the fundamental rights, if we talk about, they mostly talk about the political rights.
Do you think it is the reason? This is the reason because majority of them talk about political rights. Because majority of them talk about political rights. They emerge from fundamental rights. No.
We can infer
No. Absolutely not. How can you say it emerges from fundamental rights?
state are
Fundamental rights are, please. Yes, fundamental rights are?
they are not infringed. So,
They are not infringed. So
state not able to place it together.
no, but why, the question, what you are saying is absolutely fine. What you are defining is what are fundamental rights and what are directive principles. And you are talking about their relationship. What I am saying is, what I am asking is that why can we say that fundamental rights guarantee economic democracy, whereas political democracy, and directive principles guarantee economic and social democracy? That is what I am saying. Empowering the people, okay. And in fundamental rights, they are not empowerment.
It was imposed by the political grounds like the right to untouchability and right against exploitation.
Those are?
Those are imposed by on political grounds like state is also included in it. Here they are doing by themselves some general directions.
No, you missed the mark. You were on the right direction, but you missed the mark. Why? Let's understand this. When you say they are for political reasons, it is absolutely fine. But when you say it is being imposed by the political by political grounds, it is wrong. देखो, इस तरह से समझो. Why do we guarantee why do we have fundamental rights? We have fundamental rights because every individual, every section of the society will enjoy these rights for better enjoyment of their political rights. When you guarantee fundamental rights to each and every section or everyone, that what is the consequence of it? It will have a political consequence. What will be the political consequence? The political consequence would be that once you guarantee fundamental right to each and every section of the society, their political rights will be guaranteed. Once you guarantee their political rights or once you guarantee their fundamental rights, the consequence of it would be that each and every section of the society will enjoy same political rights. Let's understand this. I did say Article 15 Clause 2 was social in nature. So, if Article 15 Clause 2 says that no one will be denied or discriminated against while providing them access to public places. When you guarantee equality here, you are also guaranteeing that those who otherwise may be discriminated against, now they will not be discriminated against. Because they will not be discriminated against now, they will enjoy better political equality, or they will enjoy more they will enjoy more political rights, or at least equal political rights to that of others. If the state discriminates amongst individuals on the basis of whatever social reasons, not providing them access to similar access to public places, which means what? Which means, suppose, just so that you understand this, I am breaking this down further. What am I saying? If suppose I belong to a certain section of the society which previously, because of some historical and cultural factors, if we were not given the same kind of access to public places like that of others, what used to happen? Scheduled castes, when we talk about this idea of scheduled castes, what used to happen? They were denied certain things like access to certain places. They could not enter temple, they could not use in certain cases they could not use the same road which were used by others. They could not use the same roads that were used by others. Now, if these rights, if we are still deprived of these rights, do you think they will enjoy political equality? No. They will not enjoy political equality. If they are still denied these rights, if people or a certain section of the population are still denied these rights, do you think they will still enjoy the equal say in political decision making? No, absolutely not. कैसे हो सकता है? हो ही नहीं पाएगा. I am repeating myself again. Just listen to me very carefully. What am I trying to say? I am saying that when we talk about Article 15 Clause 2, which talks about access to public places, or if we talk about ideas of untouchability, prohibition of untouchability under Article 70, just for a hypothetical situation, imagine that these rights no more exist. These fundamental rights are no more in existence. They are no more in existence. What will be the consequence of it? Can we say these rights for the certain section of the society which is guaranteed these rights, now will they enjoy the same kind of political, same kind of say in political decision making that they enjoy as of today? Can they enjoy the same say in political decision making that they enjoy today? Absolutely not. It cannot happen. So, suppose an individual belonging to a certain section will not be allowed to access like roads. This is what is written. So if they are not allowed to access public roads, will they be allowed to use public places for suppose political reasons? No. Can they enjoy similar say in political decision making then? Absolutely not. Absolutely not. Now just think of it. Now return back to the same point. Fundamental rights guarantee fundamental rights guarantee political democracy. Why? The consequence of fundamental rights is that ultimately every section of the society will have equal say in political decision making. This is the consequence. This is the consequence. But that is not the case when it comes to directive principles. What is the consequence of implementation of directive principles? Implementation of directive principles would affect social decision making. It will affect economic decision making, not political decision making. Yes, ultimately the consequence will be there also. We cannot completely segregate these things. But if you look at it from this very direct perspective, not what is the spillover effects, leave aside the spillover effects, just look at the direct consequences of it. The direct consequence of it will be that they will be more socially and economically empowered. Whereas the consequence of fundamental rights is that they are more politically empowered. Have you understood this idea? What am I trying to say? What am I trying to say? I am saying that yes, there are some fundamental rights that we have, like Article 15 Clause 2 or Article 17 of the Constitution, which talks about some social aspects. It provides us some social rights. But what is the consequence of it? The consequence of it is, if we are denied these rights, what is going to happen? That section of the population is not going to have the same say in political decision making. Whereas if you deny directive principles, they are not going to have the same kind of say in social and economic decision making. And that is the reason why fundamental rights are said to guarantee political democracy, whereas directive principles are said to guarantee social and economic democracy. Clear? Understood this idea? Is it clear? Any confusion, I'll explain again. This is very important. Generally, we tend to do what? We tend to learn certain things, not understand it. Like yesterday when we were talking about backbone of the Constitution. So you tend to learn these things. You do not tend to understand. If you do not understand, it becomes further difficult to learn. But if you understand this, there is no more problems. You will never have to learn it again. You will never have to learn it again. So the idea is always about understanding. And why do we say fundamental rights are guaranteeing political democracy and not social and economic democracy? Because if we are deprived of it, the effect of it would be more political. The consequences of it will be more political. We will be deprived of what? The same say in political decision making. And that is the reason why presence of fundamental rights ensures that we all have almost similar say in political decision making. क्लियर? ठीक है, आप कुछ प्रैक्टिकल एग्जांपल से देखो. बीएसपी एग्जिस्ट करती है ना, पॉलिटिकल पार्टी एग्जिस्ट करती है बीएसपी. व्हाट इज द बेसिक, if you look at the whole idea behind the political party, it is to take care of certain rights that a certain depressed section of the society may not have been enjoyed. And so once this political party comes to power, they can redress such wrongs. But if you deprive fundamental rights, so will this political party have the same kind of say? If you deprive them of fundamental rights that are given to us, will they have the same kind of say in political decision making? Absolutely not. That is the reason why fundamental rights are said to guarantee political democracy. Understood this idea? Third point. Fundamental rights are fundamental rights are negative obligations of the state. Fundamental rights are negative obligations of the state, whereas directive principles are positive obligations of the state. They are in the form of affirmative actions. They are always in the form of affirmative actions. Now, why are we saying negative obligations of the state? See the language. The state shall not. What is the general language that is used in fundamental rights? The state shall not. This is the language that is used. The state shall not discriminate. The state shall not discriminate. The state shall not deprive. The language is that it ensures that the state is refrained from taking certain actions, encroaching upon our rights. The state is refrained from encroaching upon our rights. The state shall not. Negative obligations of the state. Whereas if you look at the language of directive principles, the state shall endeavor. Generally, you will find this is the state shall endeavor to provide every citizen. This is the language that is there. So you can see, on one hand, the state is directed not to do something. On the other hand, the state is being directed to do something. So directive principles are positive affirmations of what the state shall do, and in fundamental rights, the state shall refrain from doing something. Negative obligations of the state. Finally, the last point, the fourth point here. Fundamental rights are static. Directive principles are dynamic by nature. Directive principles are dynamic by nature. Now, this is also something that you will say, how comes fundamental rights are static? आप ही ने बताया था Article 21 of the Constitution has evolved. So how come it is static, or how come it is dynamic? See, if you look at the language itself, if we talk about the idea of, let's understand this. Directive principles, we just said it is to guarantee social and economic democracy, or social and economic empowerment. Can the concept of empowerment or development ever be static? What is how we conceive development today? Will this be the same definition of development after 10 years or 20 years? Absolutely not. How we conceive the idea of empowerment today? Can this be the same definition of empowerment 20 years from now? It can never be that. And that is the reason we say that when it comes to directive principles, they are dynamic in nature. They are not static. They are not statics. A simple idea, if you consider, just see, when we talk about the ideas from 1950s, how we have conceived that what is empowerment for women. Now, what is empowerment for women? Now, 1950s, we started this idea by somehow ensuring that if we could provide social equality, somehow that would be steps taken for empowerment. Today, the concept of empowerment is, who are you to decide what is empowerment? Yahi hai na definition. It is up to them. It is up to women. They themselves will decide. See, the definition has changed. The definition has changed. I will not impose anything. If I impose anything, that is lack of empowerment, not empowerment. So who am I to decide what is empowerment? Change ho gaya na definition. So when we talk about the nature of directive principles, it is always about this. When it is said, the state shall endeavor to provide the weaker section of the society with some steps with respect to welfare. Now, what is the meaning of welfare? What was the meaning of welfare in 1950s and what is the meaning of welfare today? It is completely different. Welfare in the 1950s means कि हाँ 2 वक्त का रोटी मिल जाए. Welfare today means they should have universal health care. Ayushman Bharat schemes of government of India takes up that. Now, etc. etc. National Food Security Act. Everyone should have eliminating hunger. All these things that are the case. So, what is the nature? The nature of directive principles is dynamic. It's not static. 5 years ago, how we will implement, how we would have been interpreting directive principles and how we interpret it today, they are two different things. Clear? So, it is dynamic in nature. Secondly, why am I saying fundamental rights are static? When we compare fundamental rights with directive principles, not saying that fundamental rights are absolutely static. It means when we compare fundamental rights to that of directive principles, we find that, okay, fundamental rights are talking about some basic rights. Directive principles are more like, the scope of it will change. It would be very dynamic and it would change the ambit and scope that is there. It will be change, it would change dramatically. That will not be the case when it comes to fundamental rights. Even if Article 21 of the Constitution has been interpreted by the Supreme Court in the manner that it has been interpreted, but it still always deals with aspects of dignity, aspects of life. It does not go into or encroach upon some other aspect, some other sphere. That is not the case. That is not the case. So, when you compare directive principles to that of fundamental rights, you find directive principles are more dynamic than that of fundamental rights. This is what we mean. Clear? Absolutely clear? So, this is the difference between fundamental rights and directive principles. Fundamental rights and directive principles, these are the basic differences. If you get a question, what is the nature of directive principles? The answer is what you have written in directive principles. It is non-justiciable, clear? It is positive obligations. It ensures social and economic democracy, and it is dynamic. This is also the answer to what is the nature of directive principles. Clear? Absolutely clear? Now, before we get into discussing directive principles itself, there is one more topic that I have to discuss before this, that is relationship between directive principles and fundamental rights. So, give this subheading, relationship between directive principles and fundamental rights. Relationship between directive principles and fundamental rights. Don't write anything, just listen to me. What am I trying to say? If you see the Constitution of India, under Article 37 of the Constitution, it says directive principles are not enforceable. Whereas, based on our previous discussions, now we know Article 13 of the Constitution and Article 32 of the Constitution makes fundamental rights enforceable. So, if you look at the relationship that is there between Part 3 and Part 4 of the Constitution, what is this relationship? This relationship is directive principles are not enforceable, fundamental rights are enforceable. Hence, directive principles will always be inferior to fundamental rights. Directive principles will always be inferior to fundamental rights. Why? Because as what has been written in the Constitution, Article 37 making one of it non-enforceable, whereas Article 32 or for that matter Article 13 makes fundamental rights enforceable. And this was also the view of the Supreme Court in the Champakam Dorai Rajan case that happened in 1950. The initial view that was there, Champakam Dorai Rajan versus the state of Madras case, the Supreme Court said that fundamental rights are always to override directive principles. They are going to override directive principles. Why? Because directive principles are not enforceable, fundamental rights are. So if directive principles, or in pursuing these directive principles, if there is a law that is enacted by the parliament or by the state legislature, and that law somehow contradicts any of our fundamental rights, in that case fundamental rights would override, directive principles would be declared as unconstitutional, or the law that that has been enacted to pursue directive principles, that will be declared as unconstitutional, void, which means it will not be enforceable. Clear? This is the literal meaning. I am repeating myself. Article 37 declares directive principles to be non-enforceable. Article 32, Article 13 declares the fundamental rights or makes the fundamental rights enforceable. Hence, the Supreme Court initially was of the opinion that if there is a contradiction between directive principles and fundamental rights, or if there is a law that has been enacted by the government or by the legislature, and any policy that has been implemented by the government in pursuing the objectives or the directives that have been mentioned in directive principles, but in somehow this law or these steps contradict fundamental rights, in that case it will be declared as unconstitutional and hence will not be enforceable. Clear? So the traditional view, or if you look at the literal relationship, it is this: the directive principles are not enforceable, fundamental rights are, hence directive principles will be inferior to fundamental rights. However, the Supreme Court changed its opinion since the 1950s itself. Since the 1950s, there was a case called as Kerala Education Bill case. Later on in the Supreme Court, there was a case called as Chandra Bhavan Boarding and Lodging versus the state of Mysore. 1969 case it was there, and in both the cases the Supreme Court held that directive principles and fundamental rights are not contradictory to each other. Directive principles and fundamental rights, they are not contradictory to each other. Why? Because their objectives are to establish democracy, political democracy of the fundamental rights, and social and economic democracy of directive principles. So the objective is not contradictory. The objective is to ensure an ideal setup, that is to ensure not only just political but social and economic democracy as well. Because the objectives are not contrary to each other, in that case it is upon the state to ensure better implementation of directive principles. And because the Constitution uses the term state, it does not just include the executive and the legislature, it also includes the judiciary. And the Supreme Court said that because of this, there is a duty of the judiciary to ensure or to interpret directive principles in such a manner that it is not contrary to fundamental rights. Thereby, the judiciary, in this particular case, the Supreme Court comes up with something called as theory of harmonization. The Supreme Court comes up with something called as theory of harmonization. What is theory of harmonization? Theory of harmonization says that they are in harmony with each other. They are not contradictory to each other. Both of them, that is directive principles and fundamental rights, they are in harmony with each other. So we need to interpret them harmoniously. We need to ensure that they are not contradicting to fundamental rights. In fact, the Supreme Court went ahead and said that in certain cases we can also interpret as directive principles being reasonable restriction on fundamental rights. In certain cases, the Supreme Court went ahead and said that directive principles can be considered as reasonable restriction on fundamental rights. And thereby, from that decision or from 1957 itself, the Supreme Court has interpreted lot of steps that have been taken by the government, which can be considered by the government, can be considered as a violation of fundamental rights, but it has been interpreted in such a way that those steps have been implemented, those directives have been implemented without being contrary to fundamental rights. Let's take an example. Directive principles say that slaughter of cows should be prohibited by the state. However, fundamental rights provide us the right to choose our occupation. What economic activities we indulge into, that is up to us. It is one of our fundamental rights. Hence, if I enter into something which leads to slaughtering of cows, it is one of my fundamental rights. It is one of my fundamental rights. It's not against, it's not against what you can say my fundamental right. It is given to me. However, the Supreme Court said no, it is not. And number of directives that this one of these directives that are there mentioned under, I think, Article 43 of the Constitution or 47 of the Constitution, it has implemented that. Similarly, we have the right to choose our occupation. Again, going by that same idea, we have the right to choose our occupation. So, do I have the right to open liquor stores? No, we don't. Why? Because again, one of the directives says that it is the responsibility of the state to maintain health. It is the responsibility of the state to maintain health. So what happens? The state issues licenses. The state issues licenses, and there is a limit that is there. There is a limit. But this, and no one can sell liquor without those permits and those those licenses that are there. I cannot start taking यहाँ से लिया और वहाँ बेचना शुरू कर दिया. I cannot do that. In fact, even if I open that particular store, I can be prohibited to do that by the state. The state can come up with laws against it. Example, Gujarat and Bihar. Example of it is Gujarat and Bihar. Gujarat has been implementing this idea from long, a dry state. Whereas when it comes to Bihar, very recently they have implemented this idea. So previously, कुछ तो लोग होंगे जो they would have been selling liquor. Suddenly they are deprived of it. So it is, if you go by literal interpretation, it is contradictory to my fundamental right to choose my occupation. But still it is permitted by the court. It still continues. It is permitted. Why? Because the Supreme Court says theory of harmonization. Theory of harmonization. And because of this theory of harmonization, the state was able to implement number of directives. And specifically certain very specific steps were taken by the government, by the legislature to implement specifically Article 39B and Article 39C of the Constitution. And what is Article 39B and C of the Constitution? Article 39B and C of the Constitution deals with provisions to ensure that there is no concentration of wealth. To ensure there is no concentration of wealth. It talks about the state having the responsibility to ensure that there are proper redistribution. It should not be concentrated in one of the sections of the society. And accordingly, the state has taken up a number of steps in this regard. Example being privatization of banks. The state deprived some individuals. When we talk about nationalization of banks, some individuals who were previously having the bank that was there, such bank, they were their property. It was their property, and right to property was a fundamental right. It was something that was amended in 1978, but before that it was A fundamental right. Before that it was fundamental right. Nationalization of bank was done when? 1969. Before the right to property was excluded from fundamental rights, before it was excluded from fundamental rights, nationalization of bank was done, depriving some individuals of their property. Similarly, Privy Purses Abolition Act was taken up. What was Privy Purses Abolition Act? There were when integration was done, when India was integrated, in that case, Sardar Vallabhbhai Patel, when he was taking up integration, so he had this strategy wherein he used to propose that all these princely states that were there and these princes that existed, they were offered that, see, if you join Indian Federation, you will have your property. The state will not encroach upon them. The state will not nationalize it. The state will not take it over. You will enjoy your property rights. And in addition to the enjoyment of your property rights, the state will give you a monthly pension. The state will give you a monthly pension, which was called as Privy Purses. Indira Gandhi comes to power, she abolishes Privy Purses, giving them pensions. Abolished. It was challenged in the court. But see, it was abolished. So while interpreting, while doing what? While implementing directives given under Article 39B and C, Clause B and Clause C, the legislature and the executive implemented lot of social legislations or lot of legislations which had this objective of providing some kind of social economic equality. No, specifically when it comes to economic equality, that was taken up. Why? To implement Article 39B and C. And this was contrary to, if you look at what Article 39B and C says, it is contrary to Article 14 of the Constitution. It is contrary to Article 39 of the Article 19 of the Constitution, and it was contrary to Article 31 of the Constitution, which was previously in existence. But the Supreme Court allowed it. Why? The Supreme Court said it's absolutely fine. Why? Theory of harmonization. However, the Supreme Court also said that if no other interpretation is possible, that means there is only one interpretation possible, and that interpretation makes directive principles or the steps taken by the government to implement directive principles contrary to fundamental rights, we have no choice but to declare fundamental rights or declare those laws and those steps to be unconstitutional, because fundamental rights are enforceable, they are justiciable. So if no interpretation is possible, if interpretation is possible, fine. If harmonization is possible, fine. But if no interpretation is possible, in that case, the Supreme Court said the judiciary had no choice. But to declare such directives and such steps taken by the government to be unconstitutional. And that is the reason why initially, when it was first enacted, this Nationalization of Banks Act that was there, when for the first time it was enacted, and Abolition of Privy Purses Act, when first time it was enacted, both of them was declared to be unconstitutional by the Supreme Court. Initially, both of them were declared to be unconstitutional by the Supreme Court. In reaction to this, that is both these laws being declared unconstitutional, the Parliament of India enacted something called as the 25th Constitutional Amendment Act in 1971. The 25th Constitutional Amendment, don't write, wait, have patience. 25th Constitutional Amendment Act in 1971. And what did 25th Constitutional Amendment Act did? 25th Constitutional Amendment Act added Article 31C to the Constitution. Now, remember yesterday's class, what did I say? Article 31 has been amended, it was repealed, it dealt with right to property, so it was repealed. Later on, Article 31C was again added to the Constitution. It is not Article 31, it is Article 31C. Clear? So, I did not say Article 31 Clause C, I am saying Article 31C, that is a different article altogether. So, Article was added to the Constitution, and what did Article 31C state? Article 31C stated that to implement directives given under Article 39B and Article 39 Clause C, if the Parliament enacts a law and such a law contradicts Article 14, Article 14, Article 19 and Article 31 of the Constitution, such law will not be declared as unconstitutional merely on these contradictions. Which means, if to give effect to Article 39 Clause B and Clause C, if these provisions were contradictory to Article 14, Article 19 and Article 31 of the Constitution, it will not be declared as unconstitutional merely on this ground. Which means, if it contradicts any other article, any other fundamental right, then it is to be declared unconstitutional. But it will not be declared unconstitutional because it only does what? It only contradicts Article 14, 19 and 31. Further, Article 31C also said that such a law passed by the Parliament will not be questioned in any court of law. It will not be questioned in any court of law. The Supreme Court in the Keshav Nanda Bharti versus the State of Kerala 1973 case upheld the constitutional validity of the first part of Article 31C, which means the part which dealt with any directive that is to be, directives under Article 39 Clause B and Clause C. To implement these directives, if the Parliament enacts a law which is contradicting Article 14, 19 and 31, it will not be held unconstitutional on this ground. On this ground, in the Keshav Nanda Bharti case, the Supreme Court did what? The Supreme Court upheld the constitutional validity of this. However, the second part of it, 31C, what did it say? Such a law will not be questioned in any court of law. That part was declared to be unconstitutional and void. In the Keshav Nanda Bharti case, wherein the Supreme Court said it is violative of. Why? Because it is taking away the power of judicial review from the court. It is taking away the power of judicial review from the court, and it also said that that cannot be done because judicial review is a part of basic structure of the Constitution. Judicial review is the part of basic structure of the Constitution. So, in which case was judicial review declared as a basic structure of the Constitution? In Keshav Nanda Bharti versus the State of Kerala case. Clear? Because there, sometimes you get confused. When I was discussing amendability of fundamental rights, remember, I did say it was declared. Now, there was something called as a 42nd Constitutional Amendment Act, and then it was declared unconstitutional in the Minerva Mills case. I did talk about that. So, this is something that is very important. Don't confuse that in that case it was declared as a part of basic structure. In the Keshav Nanda Bharti case itself, judicial review was declared as a part of basic structure of the Constitution. Clear? Further, then what happened? Then the 42nd Constitutional Amendment Act was enacted in 1976. Now, what did 42nd Constitutional Amendment Act do? What did the 42nd Constitutional Amendment Act do? 42nd Constitutional Amendment Act said, it amended Article 31C, and now Article 31C post the 42nd Constitutional Amendment Act read that in giving effect to not just Article 39B and C, in giving effect to any of the directives mentioned under Part 4 of the Constitution, any of the directives mentioned under Part 4 of the Constitution, if it is violative of Article 14, Article 19 and Article 31 of the Constitution, it will not be declared as unconstitutional merely on this ground. Not just 39B and C, which was held to be constitutional in the Keshav Nanda Bharti case, that yes, if there is a law that is enacted and the law is giving effect to 39 clause B and 39 clause C, even if it is violative of 14, 19 and 31, it will still be considered constitutional. It will still be considered constitutional, or more appropriately, it will not be considered unconstitutional because it is violating this. In other provisions, if it is violating any other provision, yes, it will be declared unconstitutional, but not on this basis, not on this particular ground, not on this particular basis. 42nd Constitutional Amendment Act further amends Article 31C, and now after the 42nd Constitutional Amendment, what did it read? It read that any directives, to implement any directives that are mentioned under Part 4, all the directives that are mentioned, if it is violative of Article 14, 19 and 31, it will not be declared as unconstitutional. The Supreme Court declared this to be unconstitutional. The Supreme Court declared in the Minerva Mills case. In the Minerva Mills case, the Supreme Court declared that the changes made under Article 31C by the 42nd Constitutional Amendment Act was unconstitutional and void. What was the reason that the Supreme Court gives? The Supreme Court says it disturbs the balance between Part 3 and Part 4 of the Constitution, which is a part of basic structure of the Constitution. So the balance that is there, balance needs to be maintained, and the balance has to be seen. Fundamental rights enforceable, directive principles not enforceable. So how can you make directive principles enforceable despite the fact that it is contradicting fundamental rights? It cannot be done. Harmonization is not possible. Then harmonization would not be possible. Supreme Court says it is disturbing the balance between Part 3 and Part 4, declared it to be unconstitutional, and also declared that balance between Part 3 and Part 4 of the Constitution, they are the part of basic structure of the Constitution. It is a part of basic structure of the Constitution. However, the 44th Constitutional Amendment Act obviously amended Article 31 out of the Constitution, which means if you look at the current position is that if the state, if there is a law or a particular executive act that is taken to enforce Article 39 clause B and Article 39 clause C, despite the fact that it is violative of Article 14 and 19 of the Constitution, it will still be considered to be constitutionally valid. It is still considered to be constitutionally valid under Article 31C of the Constitution. Clear? Have you understood this idea? So if we talk about the relationship between fundamental rights and directive principles, the relationship which started, with that literal relationship, the relationship that started with that literal relationship wherein fundamental rights, because it was enforceable and directive principles was not, because it was directive principles was not enforceable, fundamental rights was. So fundamental rights overrided directive principles. That relationship has undergone a change. Because the Supreme Court realized and came up with an idea. The Supreme Court realized the importance of directive principles and the role of the state in implementing directive principles, came up with theory of harmonization. The 25th Constitutional Amendment Act further clarified this relationship, wherein it said 39B and C, to implement 39B and C, if it contradicts 14, 19 and 31, it is still implementable and it will not be considered as unconstitutional merely on this ground. Later, the 42nd Constitutional Amendment Act also made certain changes. The Supreme Court in the Keshav Nanda Bharti case held this change, that is 25th Constitutional Amendment Act and addition of Article 31C and the changes made under the 25th Constitutional Amendment Act as constitutional and valid. But the second part of it, which said that such a law will not be questioned in any court of law, it was held to be unconstitutional. The Supreme Court in the Keshav Nanda Bharti case also declares that judicial review is a part of basic structure of the Constitution, and in the Minerva Mills case held that the changes that are made under Article 31C as the result of 42nd Constitutional Amendment, they are unconstitutional because it disturbs the balance between Part 3 and Part 4 of the Constitution. The 44th Constitutional Amendment Act removed Article 31 from the Constitution. So the current position is to implement Article 39B and C. Even if it is contrary, if the legislation is contrary to what Article 14 and 19 says, it is still constitutionally valid. The Supreme Court also tries and interprets the fundamental rights and directive principles in such a manner that they are not contrary to each other. Clear? So Champakam Dorai Rajan case, Keshav Nanda Bharti versus the state of Kerala case, and Minerva Mills case. These are the three cases from which this constitutional relationship has evolved. And obviously the 25th Constitutional Amendment and the 42nd Constitutional Amendment. Clear? Absolutely clear? Now write this down. Directive principles are very important for your mains examination. If fundamental rights are important for prelims, directive principles are important for mains. Very important. The fundamental rights, relationship between directive principles and fundamental rights. The fundamental rights are enforceable in a court of law, whereas directive principles are non-justiciable in nature. In the non-justiciable in nature, in the Champakam Dorai Rajan versus the state of Madras 1951 case, the Supreme Court held that directive principles cannot override fundamental rights. Directive principles cannot override fundamental rights. They shall conform to fundamental rights. They shall conform to fundamental rights, and they shall run subsidiary to fundamental rights. And they shall run subsidiary to fundamental rights. In case of any conflict between fundamental rights and directive principles, between fundamental rights and directive principles, fundamental rights shall prevail. Fundamental rights shall prevail. Next paragraph. However, in the Kerala Education Bill 1957 case, the Supreme Court observed that though the directive principles cannot override fundamental rights, nevertheless, in determining the scope and ambit of fundamental rights, the court may not entirely ignore directive principles, but should adapt principle of harmonization and shall give effect to both fundamental rights and directive principles. Under the theory of harmonization, the court held that there is no conflict between directive principles and fundamental rights. They are complementary to each other. And aim at establishing political, social and economic democracy. In view of this, the court has the responsibility to interpret the constitution in such a way to implement directive principles and harmonize the social objectives under directive principles with individual rights guaranteed by part 3. This is the mandate of the constitution. Not only for the executive and legislature, but also for the judiciary. Next paragraph. The directive principles are also relevant. To consider what is reasonable restriction under fundamental rights. On the basis of the above interpretation, The Supreme Court held many social legislations passed to give effect to directives under Article 39 Clause B and Clause C, to give effect to directives under 39 Clause B and Clause C. Can you read the sentence again? The last sentence. Write that held as upheld. Just make it upheld. Upheld means the constitutional validity of it. However, the court also stated if no harmonization is possible, the courts have no choice but to implement fundamental rights over directive principles. On the basis of above interpretation, the Supreme Court held the Bank Nationalization Act, and the Privy Purses Abolition Act and the Privy Purses PRIVY Privy Purses Abolition Act as unconstitutional as it violated Article 14, Article 19 and Article 31. Now, one question before we continue. Why was Privy Purses Abolition Act a violation of Article 14? Article 19 we understand, because Article 19, 44th Constitutional Amendment, and property was there. It was mentioned, right to property was there. Similarly, Article 31 also dealt with right to property. The question is, why does it violate Article 14? And if you have understood from the first day that if I have been talking about these fundamental rights, and if you have understood anything about that, you will know the answer. Why was it a violation of Article 14? Why nationalization, Bank Nationalization Act and Privy Purses Abolition Act was a violation of Article 14? Why is it a violation of Article 14? You are not revising. सीधी सी बात है, I am telling you this as a fact. You are not revising things. If you are revising things, you are not trying to understand. You are trying to learn. You are reading it, not revising it. फर्क होता है. Otherwise, you know the answer to Article 14. And see, remember the first day. What did I say? I said yes. Rule of law. So why this is a violation of rule of law? Yes. So there is a law, Abolition Act. There is a law. So is it a violation of rule of law? So that no one is being punished without the breach of a law. There is a nationalization law that is being passed, and the property is being taken away under the law. So how does it violate rule of law? It's not violating rule of law. So what is it violating? It's not violating equal protection of law. तो एक ही तो रह गया. It is violating equality before law. देखो, just think of this in this manner. If suppose I go to the court and I say, see, I have this property and the state is violating that particular my property rights that I have. The Supreme Court is going to uphold my right because right to property was a fundamental right. The Supreme Court is going to uphold my right to property. But when there is another individual who owns a bank, now when that property, when that right is being taken away, and if the Supreme Court does not uphold that, their right, isn't it a violation of equality before law? Isn't it a violation of equality before law? Samjhe ya nahi samjhe? See, what does equality before law say? No, there will be absence of any special privilege. Everyone is equal before the eyes of law. This is what equality before law says. Equality before law speaks of equality or completely every individual being equal in the eyes of law. Now suppose an individual who has small property and the state has violated his property rights by depriving him of that property. He goes to the Supreme Court, says, I have a fundamental right to property, and the state is taking away that right. The Supreme Court will direct the state not to do it. Clear? Now that is a treatment for one individual. On the other hand, an individual is doing what? An individual is having a bank. Now he is owning a bank, and if nationalization is allowed, which means now his property is being taken away by the state, and if he is not treated equally to that of other, isn't it a violation of equality before law? It is a violation of equality before law, and that is the reason why it is Article 14 is being violated. Just think over it. Socho. Okay, I'm telling you, there is this idea your preparation should always be, you should be constantly thinking about things. You should not be in that mode of learning. ठीक है कि एकदम passively बैठे हुए बस सुन रहे हो गया. No, think over it. Why Article 14 is being violated? Because one is being treated differently than that of others, and Article 14 prohibits it, saying equality before law. No one can be treated differently. And in this case that is happening, and that is the reason why Article 14 was being violated. Otherwise Article 14 has nothing to do with property. Article 14 has nothing to do with property. What is Article 14 have to do with? It has to do with what? It has to do with equality before law, and that was being violated. Once you safeguard rights of section of individuals, how can you allow the other section of individuals and you are not protecting their rights? If this is the case, it is a violation of equality before law. Clear? Next paragraph. The Parliament passed the 25th Constitutional Amendment Act. The Parliament passed the 25th Constitutional Amendment Act in 1971, which introduced Article 31C. Write Article 31C in the manner that I have written. Clear? Don't write small c. It is capital C. It introduced Article 31C, which stated that if the state enacts a law, giving effect to directives under Article 39 clause B and C, directives under Article 39 clause B and clause C, the law shall not be declared as unconstitutional. The law shall not be declared as unconstitutional and void merely on this ground. Merely on the grounds that it violates 14, 19 and 31. Articles 14, 19 and 31. Article 31C further stated, Article 31C further stated that any such law declaring that it is to give effect to Article 39 clause B and C, to give effect to Article 39 clause B and C, cannot be challenged in any court of law. The Supreme Court in the Keshav Nanda Bharti versus the state of Kerala, the Supreme Court in the Keshav Nanda Bharti versus the state of Kerala 1973 case upheld the constitutional validity of the first part of Article 31C, but struck down the later part as unconstitutional on the grounds that it takes away the power of judicial review, which is the part of basic structure of the Constitution. Underline this. Basic structure of the Constitution from Keshav Nanda Bharti case. Underline that. And in next paragraph, write the 42nd Constitutional Amendment. Next paragraph. The 42nd Constitutional Amendment amended Article 31C. 42nd Constitutional Amendment amended Article 31C and stated that if any law is passed by the state giving effect to one or more directive principles and in the process violated fundamental rights under 14, 19 and 31, the law shall not be declared as unconstitutional and void. The law shall not be declared as unconstitutional and void. The 44th Constitutional Amendment Act in 1978 repealed Article 31 from the Constitution. Repealed Article 31 from the Constitution. The Supreme Court in the Minerva Mills 1980 case held that the changes made under 31C under Article 31C by the 42nd Constitutional Amendment was unconstitutional and void, as it disturbed the balance between Part 3 and Part 4 of the Constitution, which is a part of basic structure of the Constitution. which is the part of basic structure of the constitution. Clear? Clear? This is, now this topic that I have just discussed, I have given it a lot of time. The reason is it is of absolute importance. You are very likely to get a question on it. It may be asked either in your prelims examination or in your mains examination, more likely to be in your mains examination. Clear? Very likely to be in your mains examination. So now be ready with this relationship that is there, be ready with it. Clear? Next, we come to Article 44 of the Constitution. Article 44. What is Article 44? Article 44 of the Constitution deals with, it deals with Uniform Civil Code. Uniform Civil Code. Not all, but some of them definitely. You have to remember. See, dekho, very unlikely that it is asked in your prelims examination. But why do you need to remember these articles? Some, at least some of which we are talking about, you need to remember them. The reason is, if you do not remember this, so sometimes you are writing your answers and you find, okay, in your essays or for that matter somewhere else, you know that there is a directive principle which substantiates what you are writing, but you don't remember the article, so you are not able to write it. It somehow becomes substantive. So, and these are the little things which are actually going to make your answers better than others. So you have to remember it. At least some of them, not all of it, but some of them. Like obviously 44, Uniform Civil Code, yes, it has been previously asked. Is it likely to be asked? Yes. Despite the fact that it has been previously asked, but it can still be asked, because it is as a part of a political manifesto of the political party in power, and they have from time to time talked about Uniform Civil Code. So it may so happen that they try and introduce it. So if they are trying to introduce this idea, yes, it can again be asked. Clear? It can again be asked. Similarly, there are certain provisions like Article 45 of the Constitution, which talks about early childhood care, which was introduced as introduced as right to education. Then there are some other articles also. Now you will find that they are important. Now, what is Article 44? It deals with Uniform Civil Code. If you see, what does Article 44 say? It says that the state shall endeavor to provide to every citizen a uniform civil code. A uniform civil code. So I do not have the time to discuss it completely, but some ideas I am definitely going to take up. What is a uniform civil code? What is the meaning of this term? Uniform Civil Code. What do you understand? What is the meaning of this term? Uniform Civil Code. See, what she says is not incorrect, but there is a better way to understand this. Whenever we talk about forms of code or forms of procedures or that are followed by the court, the laws on which or the provisions under which the court decides any kind of dispute, they are of two types. First is a criminal code, then there is a civil offense. Even when we talk about civil laws can further be divided into two. Certain laws or certain provisions which deals with public life, and some laws or some provisions which deals with personal life. Like when it comes to acquisition of land and property, that is also a civil offense. Ayodhya verdict was a civil case, it was not a criminal case. Why? It was a dispute of a land. So certain laws that are there, that are present in India, which deals with our public life, how we deal with people, and those matters that are present in those are not criminal matters, those are civil matters. And there are some rules, there are certain laws, certain provisions which deals with our personal matters. What now, when I say personal matters, what are these? What are these personal matters? Personal matters are things such as marriage, things such as divorce, things such as adoption rights, things such as maintenance rights, etc., etc. No, property rights, transfer of property rights, these are there. Previously, if we go back to pre-independence stage, in pre-independence stage, because again India is a patriarchal system, so women did not enjoy the same rights that were enjoyed by men. Women did not enjoy the same rights that were enjoyed by men with respect to all these things, whether it is marriage, whether it is divorce, whether it is adoption rights, whether it is maintenance laws, or whether it is inheritance of property. So the same rights were not enjoyed by women as they were enjoyed by men. Like women were not given inheritance rights. They were not given inheritance rights. Polygamy was prevalent in our society. It was prevalent in all religions. It was prevalent in our society. Similarly, when it came to adoption rights, when it came to divorce rights, women had limited rights or no rights at all. And because of the patriarchal way or the patriarchal society, the rights that were given, it was given to men or male gender rather than female. To do away with this idea, as soon as the constitution was formed, the constitution was, when it was being enacted, in the constitution, the Constituent Assembly debated this idea. The Constituent Assembly debated this idea when it was proposed that there shall be, one of the provisions of the constitution shall deal with something called as a uniform civil code. And in the Constituent Assembly debates, it was understood that many of the individuals within the Constituent Assembly were not in favor of. They were not in favor of including it as a part of the constitution. Why? Because of two reasons. First, they said that the prevalent view was that it will be, first of all, it will be something that will deprive an individual, or it will contradict an individual, it will contradict with an individual's fundamental right to practice of religion. Because there are lot of laws that, lot of provisions or lot of this would contradict the way in which we practice religion, because we tend to do what we tend to relate both of them, the personal laws that are there, and we also tend to relate it with the religion that we belong to. So there was one primary way or one primary reason why it was said to, there was a debate about it, that should we include it or not, because there was a prevalent view of those individuals who were actually criticizing the inclusion of uniform civil code. According to them, it would be a violation of our fundamental right to religion. And secondly, there was also a prevalent view called as, the prevalent view was that if we provide for any such provisions, it will result into a tyranny against minorities. It would be a tyranny against minorities, because it may so happen that laws are framed in such a manner that it contradicts the rights of minorities, specifically the rights of minorities. However, despite that, there was a very passionate speech that was given by an individual in the Constituent Assembly called as K.M. Munshi. I will be talking about that speech tomorrow. And on the basis of his speech, and etc., led to Article 44 of the Constitution, which today we talk as, we say as Uniform Civil Code. However, it is a part of directive principles, which means it is not enforceable. So it is not enforceable. Later on, post the constitution, etc., Jawaharlal Nehru became the first Prime Minister of India, and Jawaharlal Nehru was very liberal when it came to his outlook, his way of life. एंड दैट इज द रीजन वाई अभी क्लास खत्म नहीं हुई है. वेट, आई कैन अंडरस्टैंड, ठीक है, बट आप 2-2.5 घंटे आप बैठे हो, मैं पिछले 6 घंटे से बोल रहा हूँ. सो इफ आई कैन स्टैंड हियर and I'm do you see any times me sitting on the chair? Any day you will not find. So if I have that, I can do that. You are at least 10 to 15 years younger than me. ठीक है, तो अपनी बेइज्जती मत कराओ, कम से कम मेरी नज़रों में. So what happened was that Jawaharlal Nehru, who was a very liberal individual in terms of his outlook, in the very first, as soon as he becomes the Prime Minister of India, the then law minister, who was B.R. Ambedkar, he was directed by Nehru to come out with a uniform civil code. And B.R. Ambedkar, initially when he started this provision of enacting a uniform civil code, there were lot of problems that he faced. Specifically, personally, he faced not only just the government, because there was a huge, even in the Congress there were number of individuals who were orthodox in outlook, and they did not want for any such kind of reform, and hence they wanted the government not to continue with this agenda. However, when this uniform civil code, or the idea of uniform civil codes was being implemented, because of some political considerations, etc., it led to something called as it led to reforms in a Hindu code. Now it resulted into a Hindu code rather than being a uniform civil code. This was the reason why B.R. Ambedkar was said to be, he was alleged, it was alleged against him that he was anti-Hindu. He was anti-Hindu because he was a very outspoken individual when it came to certain practices that was there in Hinduism, and because of the law that he was trying to enact, that law specifically about reforming the Hindu practices that were there, he was alleged to be anti-Hindu. However, despite such problems, etc., there was an enactment of the Hindu code leading to reforms in Hindu religion. Technically, Hinduism or Hindu religion, when we say technically, legally, when we use the term Hindu, it also includes religions such as Sikh. They are included there. Similarly, Jains, Buddhists, all these are included as a part of Hindus in India. They are not considered to be a different religion legally. Yes, they have minority status, etc., but when it comes to religion, they are legally considered to be a part of Hindu. So the Hinduism was reformed, but never it resulted into a uniform civil code. And because of the political reasons that was attached to it, somehow it was not very much tampered with by any subsequent government. 1980s saw a very important development here, because the Supreme Court, in a very famous decision which is called as the Shah Bano decision, extended the right of maintenance to Muslim women by interpreting the code in such a manner. The law that was presented, because it did not provide for maintenance rights to women, but the manner in which Supreme Court interpreted it, that extended these rights to Muslim women. Later on, initially after the decision, the government, Rajiv Gandhi government which was there, it initially supported the decisions of the court. Later on, because of certain elections that happened and the Congress party losing the elections because of the kind of support that it gave to the Supreme Court's decision, Rajiv Gandhi framed a law which somehow undid the decision of the Supreme Court. It was considered to be one of the major mistakes that was made by Rajiv Gandhi, and that further set back any kind of discussion on uniform civil code. However, in 2014, when the BJP was releasing its political manifesto while contesting the general elections, it promised a uniform civil code. and though it was not able to deliver that then, it has again in its political manifesto added this idea of a uniform civil code. And various ministers in the government, they have been openly speaking about the need for adoption of a uniform civil code. And if you look at the political developments, it has been this. There was a report of the Law Commission also in 2015-16. The Law Commission specifically said that currently the environment in India is not suited for adoption of a uniform civil code. So what are the reasons? What were the Constituent Assembly debates? What were the decision of the Supreme Court? And what are the steps that have been taken? Why is it conducive and why the environment is not, is what we are going to discuss tomorrow. So tomorrow we are going to take up, first we are going to start with a uniform civil code, and then we are going to move to other aspects of our discussion in directive principles. If possible, I will be completing this discussion tomorrow. Thank you. Bolo.